All right, welcome back. Our next panel is a whistleblower update, and there's a lot to talk about. There have been a lot of really good cases, and I can't wait to hear from this panel. Let's start with our moderator, John LaBella, a director at AlixPartners. John's a CPA with more than 20 years of financial advisory experience. He served as chief accounting officer, corporate controller, and many other management roles for public and private companies. His experience spans a range of industries, including energy, software, consumer products, medical equipment, and many others. And having worked at public companies, I think John will provide a different perspective than we get on a lot of panels. And I look forward to the practicality that John will be injecting into this whistleblower discussion. Welcome, John.
Thank you.
Let me next introduce Cheryl Scarboro, a partner at Simpson Thacher. And as many of you know, she was formerly an associate director in the SEC's Division of Enforcement and the first ever chief of the SEC's FCPA unit. Cheryl represents corporations, financial institutions, and individuals in SEC and other regulatory enforcement proceedings. It should be great to get Cheryl's perspective here, both as defense counsel, but also because, as I think I learned from Erika in past webcasts, there's an interesting overlap between FCPA and whistleblowers. So a lot to learn from Cheryl. Thanks for joining us, Cheryl. Erika Kelton is a partner at Phillips and Cohen. She's an internationally recognized whistleblower lawyer. Her clients have literally recovered billions, with a B, billions of dollars for her clients. She's been named Whistleblower of the Year in multiple publications and has won 8 Dodd-Frank Whistleblower Awards for her clients through the SEC and the CFTC whistleblower programs, more than any other lawyer, including one award of over 32 million, another for over 3 million. Erika, it's always great to have you on the whistleblower panels. Welcome.
Thanks. It's great to be back.
And I'd like to introduce Kate Zoladz. Kate is with the SEC. She's an associate regional director overseeing the LA office's enforcement efforts in Southern California, Arizona, Hawaii, and Nevada. Kate started off as a staff attorney in 2010 and then spent time in the asset management unit. She's continued her rise up through the SEC and was most recently promoted to associate regional director for enforcement, where she succeeded John Barry, who spoke on our crypto panel this morning. Great to have Kate with us today. Can't wait to hear your perspective. Welcome, Kate.
Thank you so much, Bruce.
John, let me turn it over to you.
All right. Well, thank you, Bruce, and thanks everybody, and thanks to the great panelists we have here. You're right, Bruce. There's a lot going on in the world of whistleblower, and we're going to try and hit a range of subjects, and hopefully we'll get to them all. But as you just described, we'll hit on some of those numbers, and we'll take a look at some of those trends. We'll also get into, I think, some of those amendments that we saw come in late 20. I think there was sort of long anticipated, but I think some pretty meaningful amendments coming to the Office of the Whistleblower Program. Also in early 21, we had something coming out of the National Defense Authorization Act that extended the statute of limitations on disgorgement. We'll talk about that. We'll talk about all of these changes and generally the trends and how they impact, and we'll see it from both sides, from you know, so maybe some perspectives on defense counsel as well as perspectives on those representing whistleblowers. So, Kate, big year in 20. We're seeing 21 follow right in suit. Some big milestones hit last year, big awards. The trends continue. Why don't you kick us off and just maybe bring us up to speed on the Office of the Whistleblower?
Yeah, absolutely. So it has been a busy couple of years. So fiscal year 2020 marked the 10-year anniversary, actually, of the inception of the whistleblower program, and it was a record-breaking year in many different respects, both in terms of the number of individuals and the dollars awarded, as well as the claims processed and the tips received. So in fiscal year 2020, the Commission awarded 39 whistleblowers approximately $175 million. That number and amount of whistleblower awards exceeded any previous years. And as you mentioned, fiscal year 2021 is already set to surpass fiscal year 2020. In the first 6 months of fiscal year 2021, Over $250 million has already been awarded to 48 individuals under the program, including the largest ever award of over $114 million. So it has been a really, really busy time. And you might ask why, what has happened over the last couple of years to cause this increase. So in fiscal year, I think we can take this back to fiscal year 2020, when the commission and the staff implemented a number of efficiencies that were designed to improve the claims review and awards process, and additional resources were allocated to the Office of the Whistleblower. So in particular, we've kind of streamlined a number of our internal processes to evaluate claims better and have better coordination between the Division of Enforcement, Office of the Whistleblower, and other groups. And I know we'll talk more about this later, but the Commission also adopted some amendments to rules governing the whistleblower program that were designed to provide greater clarity to whistleblowers and increase the program's efficiency and transparency. So I think what you've seen over the last couple of years is really just the results of some streamlining and efficiencies that have been going on for a couple of years now.
Right, and we will get into those amendments, and I think they make some big changes. But yeah, and Erika, what do you think? We seeing what do you infer from that
Well, I agree with Kate, but there are a couple other observations that I'd like to make. The chief one being that I think that what we're seeing in terms of the increased numbers of awards and numbers of whistleblowers and the size is also evidence of the fact that success begets more success. When you have a program that's successful, and as Kate mentioned, we're now in the 11th year, people see large awards, they're publicized, and they start thinking about what they know and about whether they could participate in the award program. So I do think that is an important factor, important impetus for the increase in whistleblowers, and particularly really well-positioned whistleblowers in highly placed positions within their companies might have been holding back to see kind of the proof of concept for Dodd-Frank whistleblower programs. And once they had it, they stepped forward. I know in our practice, we've seen that.
Very good. So as you think about this, and maybe you were just starting to touch on it, but what really motivates whistleblowers? Let's talk about that for a moment. Is it just this moral drive to do good in the world, or is it the dollar signs that folks see out there? What really drives that? And maybe as we can think about what drives whistleblowers, I think it'd also be interesting to think about whether this work from home environment and this COVID environment, how has that contributed? So maybe starting with Kate, to the extent that you have a view on it, what's motivating whistleblowers out there? What do you see?
So, I mean, just by way of background, Congress, as you know, through Dodd-Frank, established the awards program, specifically to incentivize individuals to submit high-quality information to the SEC. So there are many things I think that can motivate a whistleblower, and certainly that includes a monetary award. It also includes wanting to do the right thing. In fact, we found that about 84% of insiders who received rewards under the SEC's program actually reported their concerns internally before reporting them to the SEC. So I think that would support the notion that they want to do the right thing. Regardless of the individual whistleblower's motivation, of course, at the SEC, our focus is really on determining whether the whistleblower provides specific, credible information that our staff can leverage in an investigation.
Very good. What about this work from home environment? Is that, are you seeing that driving more tips? I mean, when I think about it, folks are home, you wonder where their productivity is. Things are a little more distant. Are you interpreting what you think you're interpreting correctly? You have folks with a little more creative time. Maybe there's a little bit of a disconnect. I think controls are a little bit harder in this remote environment. Do you think that's contributed to a rise in tips or not, or in the quality of the tips? Or
So So, last fiscal year, the SEC received more than 6,900 whistleblower tips, which was the highest number of whistleblower tips in any year to date. To be honest, I'm not sure it's impossible to tell whether that's due to work from home. But I do think it's certainly possible that people are feeling less connected to their businesses and employers, or feel like they might have more freedom getting away from their job a little bit to report suspected violations.
So let's maybe shift gears just a bit, maybe to Cheryl, digital realty and the impact of digital realty. And now that the court's kind of clarified about the extent of those anti-retaliatory protections and the need to report into the SEC, do you think that there's an impact, or are you seeing a drop off in companies reporting internally before they're going to the SEC? What have you seen in your practice in terms of that impact?
It's hard to attribute it to any one particular thing. And so in 2018, with digital realty, we have some certainty that whistleblowers who don't report to the SEC are not going to get the same protection as it relates to retaliation. So that's now clear. But I don't know that that's at the forefront of whistleblowers' minds when they make a determination as to whether to go to the SEC first, maybe on the margins. I do think that certainly it will have some impact, because many whistleblowers who are coming forward to companies do fear retaliation, and we do know that there are significant numbers of cases in which there are allegations of retaliation. We're all aware of cases in which the SEC has addressed those issues with companies where that has been, that has been established. So it's certainly a concern. I think that even more than that, though, whistleblowers are often incentivized to go to the government first because they want to get first in line. They want to be able to make sure that they've put themselves in the best position. There is some compromise language in the statute that says that you don't lose your place in line if you go to the company first. But I don't know that whistleblowers necessarily trust that. But to me, I think thinking about this from the angle of a defense lawyer and representing companies, the most significant thing that companies worry about is whether they've created a culture in-house to support individuals who have allegations and to make them feel welcome to bring those forward to the company, that the company is going to take them seriously, is going to address them, is going to take appropriate action against individuals who've, perhaps violated the code of ethics or the securities laws, and that they're going to be protected against retaliation. So I think that all of those things are in companies' minds when thinking about how to create a program that incentivizes people to come to them first. And there are all sorts of reasons why that's beneficial to companies, not the least of which is being able to deal with it internally and not have to deal with the regulators as well. But also I think it's good corporate governance to have a system in place in which any particular allegation, whether it's a big one or a small one, comes in-house first, and the company has a chance to understand there's an issue, understand that there are these potential problems, and have a first crack at addressing them.
That's certainly always been my experience, the preference to have the opportunity to address those allegations internally without necessarily being surprised by someone coming from the SEC, especially when there's so much to whether there's legitimacy or validity to what's being alleged. But it's also fascinating to see the sensitivity around there's so much reaction to when something comes through, and so much sensitivity that I have seen over the years, that folks are a lot more careful now when allegations come through, and there's such carefulness to not be seen as taking any kind of actions that might be interpreted as retaliatory. So I think that message, in my experience, has really gotten through. Turning back to you, Erika, thinking about that and listening to Bruce in your introduction, what you more than anybody, what makes a good whistleblower client? What what do you see in terms of what's going to be a good whistleblower?
Yeah. Well, the most important thing is having somebody who is well-informed and has high-quality information. Typically, it's going to be somebody who's well-placed within a company, but not always. I mean, we've represented successfully competitors or people in the industry who are not insiders. Another factor is somebody who comes in early. That's going to be a plus for the SEC as well. That's something that they really emphasize, and obviously they are take a negative view towards those that they feel unreasonably delay. I think it's always great when a whistleblower comes with evidence, though that's not necessary. If they don't have evidence, it's good to know where the bodies are buried, right? So if they can provide a roadmap of where the SEC should look. Very importantly, a whistleblower, we like whistleblowers who are realistic. It's a long-term slog, and they need to be realistic about it, and they also need to be in for the long haul as well.
Right. Yeah, excellent. Let's switch gears a little bit here and maybe bring it back to you, Kate. You know, you touched on it a little bit, but some of these amendments that we knew they were coming. The office had indicated that these would come, and you can sort of feel some learning applied here, and really a lot going on to give some more clarity and maybe more efficiency in processing. But take us through some of those amendments that I think became effective here in December of 20.
Sure, but before I do that, I realize I committed a cardinal sin of SEC public speaking that I forgot to give the standard disclaimer at the beginning, so I'm going to give it now. This applies retroactively.
Yeah.
The views I expressed today are my own and do not necessarily reflect those of the staff, the commissioners, or the agency. So with that in mind, I'm happy to give a summary of the amendments. So as you mentioned, the rule amendments are intended to provide greater transparency, efficiency, and clarity in the processing of whistleblower awards. So the amendments enable the commission to pay more award money to more whistleblowers in a couple of scenarios that I just want to walk us through. So first, there's a presumption of the statutory maximum award amount for certain awards under $5 million, where there's no negative award criteria that are present. So this is really an important provision because historically over 75% of the awards given out in the whistleblower program have been $5 million or less. This should also translate in a greater certainty for the whistleblower as to what his award will be, promote consistency among whistleblower awards, and allow the Office of the Whistleblower to review and process meritorious award claims more quickly. So secondly, the rules amended certain definitions, such as expanding the definition of administrative action to permit whistleblowers to recover when they voluntarily provide original information that leads to certain types of settlement agreements, such as deferred prosecution agreements and non-prosecution agreements entered by the Department of Justice, a whole other category. Thirdly, the rules also provide for additional flexibility for the submissions of the Form TCR that will allow individuals who fail to comply with certain procedural requirements to nevertheless obtain an award in certain circumstances. And then finally, the rule amendments allow the SEC to devote more time and resources to processing meritorious award claims through three-strike rules for frivolous submitters and a summary disposition process for straightforward non-meritorious claims.
That was one of the more interesting provisions of it there, and I thought it was pretty gracious. What is it? 3 strikes, or you're allowed to withdraw. So if they advise you that was my interpretation. Anyway, it seems like you can go to bat a few times before you're permanently barred, I guess. It's maybe early in terms of reactions, but Cheryl, have you seen an impact, or what do you foresee with respect to these changes?
Yep, I don't know. I certainly not directly in terms of seeing an impact. I guess it remains to be seen. You know, I have heard that there might be some concern about the amount of discretion that the SEC has in determining the award and where people fit in the spectrum. Maybe that would have an impact on whistleblowers, not necessarily to increase the number, but maybe to, you know, to discourage whistleblowers from coming forward if they feel that, you know, they're not going to get a fair shake in terms of how their, you know, the value of their contribution is quantified and what percentage they end up getting. You know, I'm sure Erika knows much more about what whistleblowers are thinking about that than I do, but that's just a speculation on my part that might be a component where you might see some questions from whistleblowers.
How about it, Erika? What do you think? What are you seeing, or what do you think will come from it?
Yeah. So from our perspective, the 2020 rule changes and clarifications are really a mixed bag. The presumptive 30% award in matters that would yield an award of less than 5 million is a plus. And we definitely have seen kind of I can't really say a surge, but an uptick in the pace of those award determinations, which was really terrific, and they came in around holiday time too, so made a lot of clients happy with that, and hopefully that will help clear out the backlog. But now we're nearly half of the way through 2021, and it seems that there still is a pretty significant backlog. So I think Tom will tell on that. With respect to what Cheryl was talking about in terms of the award determination, in terms of the amount of the award or the percentage of the award, yeah, there's some worrisome changes in the 2020 rules. Now, a couple years before those rules, the SEC had put out to public comment those or similar changes. And then at the very last minute, Commissioner or Chairman Clayton said that the public comment wasn't necessary because the SEC had discretion all along, which was puzzling to the whistleblower bar and frustrating to whistleblowers. You know, the fact that the amount of the award can now be considered in determining where in the spectrum between 10 and 30% an award should be slotted is quite frustrating and quite concerning for individuals who have either blown the whistle or considering blowing the whistle. Because if they are A+ whistleblowers and provide really superior information, not known and that wouldn't be known to the SEC, and then provide ongoing assistance of very high quality. You know, we have clients who've done that, who've really worked shoulder to shoulder with the SEC, and where we have provided experts, interpreters. We've even developed bespoke software to do voice recognition for the SEC. I mean, unusual and significant things, and which have increased the value of the recovery to the SEC. And yet, because that value increases, the amount of the award is, we haven't gotten the award determinations yet, but there's a peril that those amounts will be depressed simply because of the success and the amount of the potential award. In terms of the reactions of clients and potential whistleblowers, I mean, after those rule changes, my phone was ringing off the hook. People are really concerned, and it is something that current clients ask about, and it's something that people who are considering being reporting to the SEC are concerned about, and it is informing their decision making.
That's interesting. Kate, I know you're kind of bound by limits, but that's pretty fascinating from both Cheryl and Erika. Any Any thoughts on that or response?
I think we're just, we're always looking for ways to increase the efficiency and improve the program and the transparency. So I think it's certainly good to hear those comments, and I know people take that to heart.
Yeah, no, very good. Let's see, maybe another sort of technical side here, maybe on the legal side, there was also something that came out at just the very beginning of the year here in January of 21, where the National Defense Authorization Act had an extra piece snuck in there talking about the extension of the 10-year statute of limitation regarding disgorgement in matters where there's scienter. Cheryl, do you want to maybe take us through that, if you would, just sort of what that means, and do you expect that this might have an impact to open investigations on maybe older tips or older issues?
Sure.
Take us through that, please.
Sure. So tucked into the defense bill were some provisions that had direct impact on the SEC's enforcement program, one relating to disgorgement and the other, the statute of limitations. Both, I think, in part, addressing some landmark Supreme Court cases, Kokesh and Liu, both of which had put some limitations on the SEC's enforcement program, one dealing with whether disgorgement was an equitable remedy or more like a penalty, and if it's more like a penalty, then it would be subject to the statute of limitations, and that's the way the court ruled there. And the other relating to the ability to get disgorgement in federal cases. So with the statute, it basically clears up these two questions. The first, I think, which is the more significant, really has to do with the statute of limitations. Disgorgement, I mean, there's now the clear ability to get that in civil cases. I think the SEC had already used it had been able to get disgorgement by leaning on the court's equitable powers before that. But so I don't necessarily view that one as significant. But now we have an extension of the statute of limitations from 5 years to 10 years, which is, a quite significant jump in terms of that time period. And the way that the NDAA writes it, though, it's for violations that involve scienter or an intent to deceive. And I think that that's interesting, in part because, I deal with lots of FCPA cases. And so there's an open question about whether this extension of 10 years applies to FCPA cases. And if so, is it just ones with bribery, or is it, because obviously books and records and internal controls, you don't have, scienter. And is corrupt intent the same thing as scienter or intent to deceive, because they are slightly different? Maybe, courts down the road will deal with that. Many FCPA cases are quite old. The facts are, quite old. And so I would expect that statute of limitations of 10 years versus 5 would be significant for that program. So really, I think in the end, this can be, quite a significant expansion for the inventory that the staff has, because being able to reach back for, and bring, get disgorgement, bring remedies for cases that, that have, facts that go back 10 years. I mean, that kind of can open the floodgates in some ways in terms of that, the number of cases, the amount of conduct to be worried about. So, I do expect it's going to come up quite a bit, that we'll be seeing them reach back. In my own mind, I think there's still some limitations in terms of doing that. The older the facts are, a lot of times the harder they are to prove, particularly when you've got to deal with evidence and individuals and memories. There are lots of reasons that old facts can make, very bad cases. So we'll see how aggressive the staff is in terms of using that new power.
Yeah, great points. And I don't know, Erika, this is still pretty early, but especially this idea on just the quality of facts and the crispness of the detail as you reach back in years. Have you seen an impact yet, or does this have you look at older cases or older clients that you maybe bring back into the
Well, it's interesting what Cheryl was talking about in terms of potentially impacting the SEC's inventory. We do have a couple of FCPA cases where some of the best evidence, and these are active investigations, where some of the best evidence is on the older end. And so we're optimistic. I mean, obviously it's the SEC's, in this case, the DOJ's choice also as to how far back to go, but we're optimistic that that this change will be helpful. It's interesting in terms of what we're seeing about people who are coming in. We're not really seeing people so much who are coming in with older evidence or older potential cases, but we have been contacted by a couple of people who were barred under Kokesh, who are now holding up their hand again and saying, well, what about now? Is it okay? Do we have something? And unfortunately, in those cases, they weren't really terrific for other reasons, in addition to the statute of limitations. So we're not going ahead with those. But yeah, it's in some ways it's too early to tell. This is just the beginning, I think.
Well, let's shifting gears again and sort of the maybe seeing, and maybe this is anecdotal, maybe it's in the numbers as well, but seeing less of the retaliatory cases, 21F cases. Do you have a read on that? Maybe starting with you, Erika. Is that just, have companies just gotten the message that the perils of taking actions, whether they're real or perceived as retaliatory?
Yeah, well, I think there are two components to 21F, and I think each is kind of on a different path now, if you will. One is retaliation against the individual, and unfortunately, companies are continuing to retaliate and to blackball individuals, and shooting the messenger is still way too common. So we're not seeing so much a shift in retaliation, but what we're seeing is that we think that the SEC's past enforcement actions around chilling and impeding, and by that I mean they took a number of enforcement actions against companies that had in their agreements, whether it's confidentiality agreement, employment agreement, or severance agreement, had provisions that in some way penalized or chilled reporting to regulators. And in the early days, we saw a lot of those agreements. And then I think in direct reaction to those enforcement actions, they had a profound deterrence impact. It is rare to see anything like that now. And I have to say that that is true for agreements that I see coming from overseas too. I mean, it's been really pretty much the most striking deterrence impact I've seen in my career.
Yeah, that it does make sense, and those were high profile, and it always does sort of make your jaw drop when you would read some of the actions that companies would take, or even embedded right into the agreements, as you say.
Yeah.
Okay, so let's shift gears maybe a little bit again, and given talking about sort of large and impactful cases or large and impactful programs. Maybe turning it back to you, Cheryl, thinking about how you advise your clients on when is it time to go to the SEC, and let's assume here it's just internally. I guess you don't know one way or the other whether they've gone to the SEC or not. But when there's internal reporting here, and how do you think about that? How do you think about when it's time to go to the SEC, the timing of it, or the factors that you weigh in advising clients on when it's time to knock on the SEC's door and let them know what you have?
Yeah, it's really, really tough to sort that out, and a lot of factors go into that decision. Clearly, one of them being whether you think you've got a potential issue and how big it is, and whether it goes, whether it's something that you think is relatively small and contained and has been addressed and remediated, or whether you think it's something that's more systemic, involves higher levels of the company, large dollar amounts. We're talking about whistleblowers today, and I think that that's an important calculation too. Is it possible that regardless of whether you might have made a decision to handle this in-house and document it and deal with all of that, is it possible that there's a whistleblower? And if you think there is a whistleblower, then you're more incentivized to go forward first, because you do want to be able to get out in front of that if you can, in front of the government first. You want to be proactive. You want to be able to show them that you've, give them your side of it and whatever facts you've developed, and also try to, get any credit you can as the company would like to get credit for having reported it first. But also it puts you in a different light if you wait and a whistleblower goes forward first. It changes everything in terms of your relationship with the staff, maybe the way the investigation is handled. It really can make a big difference if you wait for that whistleblower to go in before you do. And so that one thing could be enough to tip the balance, when otherwise you might have felt like you could deal with this yourself in-house, and it wasn't the kind of thing that you thought you needed to self-report.
In thinking about that, what do you do, or how do you advise folks when the cases or the facts alleged or however it comes, they just don't seem to have merit on the face right from the beginning? How does that calculate into how you're going to react to that?
Well, so assuming again that we're dealing with a case where we think there's a whistleblower, and maybe this is a whistleblower who is going to go forward with allegations that we don't think have merit, that we've investigated fully, or that don't, that we think perhaps are motivated by something else. Sometimes they're, oftentimes disgruntled employees or whistleblowers, and sometimes they've got strong evidence of misconduct. Sometimes it's a mixed bag. Sometimes perhaps it isn't what we think is a violation at all. And so that can be tricky, but I think in some instances you might still want to go forward to the government, and you want to still be able to get out in front of it. And you might be even more incentivized to do it in that case, in case you think there might be a misunderstanding. There might be, in some cases, facts a whistleblower doesn't know that change things in terms of whether something really is a problem. And so there may well be good reasons for you, even if you don't think there is a violation, to go forward to the government as soon as you can and let them know, what you think are the important facts.
Kate, I'll just ask you, and I assume you'll say yes. Come to us as when you can, when you know. But do you have just love to hear your view as well?
Yes, come to us when you have something. No, I mean, from my perspective, I think it's always better to report sooner than later. And we certainly hear from whistleblower counsel who come and say, look, I don't think this actually has any merit, but in an abundance of caution, like, we're coming to you, we're reporting to everybody. We want to make sure that you see this, and we don't spend a bunch of resources down the road if we can explain to you up front why this is an issue. So I think sooner is always better from my perspective.
Well, very good. Let's maybe to kind of close us out here. I think we're getting close on the time. And maybe throw the question of, what would you like to see, or what improvements or change, if you could, what would you like to see improved or changed about the whistleblower program? And I think let's start with you, Cheryl. What are your thoughts on what would you like to see different, improved, changed?
I think that the SEC did try to strike a balance because of comments from both sides relating to whether whistleblowers would ever be incentivized to report things internally. And I think there was an attempt to try to keep that avenue open and to acknowledge that and the importance of that. I'm not quite sure how you would structure a program to make sure that avenue is still attractive to whistleblowers, and that there is, that they don't feel that they're losing something by going internally first. But I do think that oftentimes companies feel that employees don't consider that as a first option. Companies will do what they can to try to get the word out, to make whistleblower channels internally as user-friendly as possible, to make it clear from a cultural point of view that they value whistleblowers and they value hearing from employees about their concerns, and that they take them seriously, and they try to be more transparent about the steps they're taking to address the issues when they come forward. But I think that would be one place that companies feel a frustration, that there's an incentive to go to the government first without letting the company know first about potential issues.
Yeah, I agree with that a lot. As I think about that, there is a balance to strike here, and just from my own experience, it is always better if you have an opportunity internally to try and address it and manage it and deal with, versus the unknown, someone doing an end around going straight to the commission. Erika, I'm sure you have some views.
Yeah, I do have some views. I think it's really important to understand that people call me and call other whistleblower lawyers most often after they have raised concerns internally and after they've been either disregarded or dismissed, either literally or figuratively. I think it's also important to recognize that it's not a one-size-fits-all situation. Not every company with an internal reporting mechanism is doing it right. And not every company is evil and bad. But I only get the calls where internal reporting isn't doing a good job. And I think it's important to go back to what Kate cited, the statistic that Kate cited, which was, I believe, the SEC's own study. And there have been other studies also of internal reporting and whistleblowing. And by far, whatever the number is, whether it's 90, 84%, 75%, most people raise their concerns first internally. Might not be through formal internal reporting channels, but they're talking with their supervisor, they're talking with others, and it's only after that fails that they, generally speaking, that they reach out. I do agree with Cheryl that I think that in the rulemaking that the SEC did a really good job in striking a balance between encouraging internal reporting, but not mandating it, because it shouldn't be mandated in every instance. In terms of other improvements, I mean, the frustration for whistleblowers, one of the biggest frustrations that whistleblowers have is with the pace of award determinations. It is so slow, even recognizing the efficiencies and the terrific job that the whistleblower office has done in clearing some of the backlog, particularly with these smaller 30% awards. Some of these award determinations are taking 3 years or more, and that's after the enforcement action has concluded. I mean, people in some instances are waiting longer for their award than it took to take the enforcement action. And there's particular frustration about the pace in the context of the SEC that penalizes quote unquote unreasonable delay in determining in the calculating the amount of the award, yet the SEC can take multiple years. So there could be real improvement there with the setting of deadlines. Perhaps I know that Senator Grassley's office, there's legislation out there imposing deadlines. I do think that just generally communication, particularly about whether a case is still active or not, whether it's the investigation is closed or not, is important information for an individual to hear to get closure on a matter.
Well, I see Bruce has rejoined, but I just got to give Kate real quick. And I know you're probably handcuffed in responding, but
I am a bit handcuffed in responding. But I, kind of as I mentioned before, I do think we are always on the lookout for ways that we can increase efficiency and transparency, and we have made an effort over the last couple of years to do that. And I think we can always do better. So, yep, that's about all I can say.
Well, thank you, Cheryl, Erika, Kate. Really some great views, some great comments. Bruce, I'll turn it back to you.
Thank you, John. Great job moderating the panel. And Kate, Erika, Cheryl, thank you so much for your time and for your insights here today. We really, really do appreciate it. So our final panel of the day is coming up. It's on FCPA trends and developments. It will begin at 5:30. So we will see you back here in 4 minutes for the home stretch. Thank you.